Welcome, everyone. Thank you for joining us for this Job Accommodation Network Accommodation and Compliance Series webcast titled Navigating Pregnant Workers Fairness Act Accommodation Requests. My name is Tracy DeFreitas, and I am a program leader and the director of training and outreach for JAN. Now, this Navigating Pregnant Workers Fairness Act Accommodation Request training focuses on the PWFA. The PWFA requires covered employers to provide reasonable accommodations to qualified employees or applicants with known limitations related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions, unless it will cause the employer undue hardship. This training will cover what you should know about the PWFA to navigate the law's requirements effectively, some key distinctions between the PWFA and the Americans with Disabilities Act, or ADA, and insights on engaging in the interactive process to provide reasonable accommodations. I'm thrilled to introduce our guest speaker, Jean Goldberg, attorney advisor to the Deputy General Counsel at the Equal Employment Opportunity Commission, EEOC, headquartered in Washington, D.C. Jean brings us valuable insights into the PWFA final regulations and the EEOC's perspective on implementing this law in the workplace. Jean, thank you for joining us today. It's always great to work with you. I'll turn the training over to you now.
Thanks so much, Tracy. Before we dive in, bear in mind that the PWFA is not the only federal EEO law relevant to accommodations for pregnancy, childbirth, or related medical conditions. Under some circumstances, Title VII or the ADA can also apply. Title VII says sex discrimination includes discrimination based on pregnancy, childbirth, or related medical conditions. And that can sometimes reach situations where an employer allowed a type of accommodation to other employees for other reasons, but would not give it for pregnancy. And the ADA, of course, requires accommodation absent undue hardship for an impairment that substantially limits a major life activity, which may, in a given case, include an impairment connected to pregnancy, childbirth, or a related medical condition. So then why did Congress pass the PWFA? It found that notwithstanding these Title VII and ADA protections, pregnant workers were still losing their jobs, being forced to go out on leave, or being forced to work without accommodations. Congress responded by enacting PWFA to provide a direct right to qualified applicants or employees with known limitations due to pregnancy, childbirth, or related medical conditions to get reasonable accommodation absent undue hardship. So now, any or all three laws, Title VII, the ADA, and the PWFA, may apply. Next slide. The PWFA went into effect on June 27, 2023, which means employers were subject to its requirements beginning that day, and EEOC began taking PWFA charges that day. The EEOC's final regulation, also known as a final rule, and the interpretive guidance issued with it, was published this past April and took effect June 18, 2024. EEOC has also issued numerous short PWFA technical assistance resources, including a summary of the key provisions in the final rule and a What You Should Know publication. For your reference after the webinar, you'll find at the end on slides 42 and 43 links to the regulation and interpretive guidance that I'll be discussing today and related materials. Next slide. So what does the PWFA do? Congress put 5 prohibited employment practices in the statute. First, denial of accommodation. An employer cannot fail to make reasonable accommodation for a qualified employee's known limitations related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions, absent undue hardship. Second, forced accommodation. An employer cannot require a qualified employee to accept an accommodation other than one arrived at through the interactive process. For example, this provision addresses situations where there's no accommodation request, yet the employer unilaterally imposes an accommodation the employer simply assumes is needed. This provision also addresses situations where an employee does request accommodation, but the employer instead provides an alternative to what was asked for without any interactive process. For instance, as in example 57 of the interpretive guidance, where an employee requests additional breaks as an accommodation, and instead, the employer unilaterally imposes an alternative accommodation, switching the employee to a different position without engaging in any interactive process. Next slide. Third, denial of employment opportunity. An employer cannot deny an employment opportunity to a qualified employee because that person needs or will need a reasonable accommodation. An example of this would be refusing to hire a pregnant applicant because of a concern they'll need leave as an accommodation to recover from childbirth. Fourth, forced leave. An employer cannot require a qualified employee with a known limitation to take leave, either paid or unpaid, if another reasonable accommodation exists absent undue hardship. This provision gets at situations where, rather than provide an accommodation that would allow a worker to remain on the job, the employer instead requires them to go out on leave. Of course, leave can be a reasonable accommodation, but that's where it is requested or selected by the employee, or where it is the only reasonable accommodation that does not cause an undue hardship. And fifth, taking adverse employment action. An employer cannot take adverse employment action against a qualified employee because they requested or used a reasonable accommodation. Next slide. In addition to these 5 prohibited employment practices, the PWFA also prohibits retaliation for protected EEO activity, including for requesting or using an accommodation. And PWFA has an anti-coercion provision as well, which, borrowing from ADA's interference provision, prohibits harassment, intimidation, or threats that interfere with exercising PWFA rights or helping others to do so. Next slide. So what are some examples of PWFA accommodations? Additional longer or more flexible breaks to drink water, eat, rest, or use the bathroom. Exceptions to food or drink policies to allow a worker to have a water bottle or food. Modifying equipment, devices, or workstations, such as providing a stool to sit on or a way to do work while standing. Making an exception to a uniform or dress code, or providing safety equipment that fits. Next slide. Changing a work schedule, such as having shorter hours, part-time work, or a later start and end time. Telework, temporary reassignment, leave for appointments with healthcare providers, light duty or help with lifting or other manual labor, or leave to recover from childbirth. Now, these are just examples. There can, of course, be many others. But like under ADA, a particular accommodation need not be provided if it would pose an undue hardship on the employer. In addition, if there is more than one effective accommodation, while the employee's preference should be given primary consideration, the employer has the ultimate discretion to choose among effective reasonable accommodations. The PWFA, in other words, allows an employer using an interactive process to select an alternative effective accommodation that's easier to provide or less costly than the one the employee requested, even absent undue hardship. But remember that in selecting between options in the interactive process, an employer must select an effective accommodation and make sure that the accommodation provided is one that allows the employee to attain the same level of performance or to enjoy the same level of benefits and privileges as are available to similarly situated others without limitations. Next slide. Leave may be a commonly requested accommodation under the PWFA, such as for appointments with healthcare providers, including before pregnancy for those trying to become pregnant, or for healthcare appointments during or after pregnancy, for recovery from childbirth, miscarriage, or other related medical conditions, and many other examples. Now, there may be situations where an employee already has another right to leave. For example, sick leave or maternity leave under the employer's leave policy, or leave under FMLA or under state law, and the individual uses that. But what if an employee requests more leave than what is available, or more than they have left under those other laws or policies? Just like under ADA, providing additional leave can be a PWFA reasonable accommodation subject to undue hardship. Note, the PWFA, like the ADA, does not require that leave as an accommodation be paid. So PWFA accommodation leave will be unpaid unless the employer's own policies provide otherwise. Next slide. So who is a qualified employee or applicant under the PWFA? The PWFA has two parts to its definition of qualified, or two ways to be qualified. The first part has the same ADA language we know well. An employee or applicant who, with or without reasonable accommodation, can perform the essential functions of the position. Many workers seeking PWFA accommodations will be qualified this way because they can perform their existing job with a reasonable accommodation. For example, the cashier who needs a stool, the production worker who needs additional bathroom breaks, or the retail worker who needs to carry a bottle of water. Next slide. If someone can't be qualified to perform their job, even with an accommodation, then we look at the second part of the PWFA's qualified definition. This is something that is not in the ADA. It's different. The PWFA statute states that even if an employee cannot be accommodated to perform the essential functions of their job, they can nevertheless still be qualified if, first, any inability to perform an essential function is for a temporary period of time. Second, the essential function could be performed in the near future. And third, the inability to perform the essential function can be reasonably accommodated. For example, let's say in the second month of pregnancy, a construction worker is told by their healthcare provider to avoid lifting more than 20 pounds for the rest of their pregnancy. Even though an essential function of the construction worker's job requires lifting more than 20 pounds, and even if there's no reasonable accommodation that will allow them to do that function, the worker may still be qualified under the PWFA. Next slide. So how does this work? For these situations, we ask, first, is the inability temporary? Under the regulation, this means lasting for a limited time, not permanent. Second, will the employee be able to perform the essential functions in the near future? The regulation says if the employee has limitations because they are pregnant, currently pregnant, they will meet the definition of in the near future. Why? Because pregnancy is always over within generally 40 weeks. So they will likely be able to perform the essential functions of their position again within that time. But where the accommodation request is not for current pregnancy, how long would be considered in the near future will depend on the facts. And of course, how long an employer temporarily suspends an essential function for will depend on what the employee actually requests and needs. Next slide. Third, we ask, can the suspension of an essential function or functions be reasonably accommodated? This will mean different things depending on the position and the workplace. But the regulation explains how this works. One or more essential functions are temporarily suspended while, for example, the employee continues to perform the remaining functions of the job, or the employee continues to perform the remaining functions of the job and other functions assigned by the employer, or the employee performs the functions of a different position, or the employee is assigned to light or modified duty. As always, if the employer can show a reasonable accommodation causes an undue hardship, the employer does not have to provide it. But before being too quick to conclude a given accommodation poses an undue hardship, remember that any suspension of one or more essential functions under this provision will be temporary. And if you are in a situation where a particular PWFA accommodation does pose an undue hardship, keep in mind, as we're well familiar with under the ADA, an employer needs to consider whether there is an alternative accommodation that it can offer instead. Next slide. So under the PWFA, what is accommodation available for? For a known limitation, which is a physical or mental condition related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions that the employee or the employee's representative has communicated to the employer, whether or not the condition meets the definition of an ADA disability. Next slide. Known simply means that the employee or applicant or their representative has communicated the limitation to the employer. Like under ADA, the communication does not need to use specific words and doesn't need to be in writing or on a specific form. Next slide. And a limitation is the physical or mental condition. In keeping with the fact that the PWFA was intended to address the full range of needs, from those that arise even in an uncomplicated pregnancy to more serious problems, the regulation defines limitation quite broadly to include even a modest or minor impediment or problem. Examples of PWFA limitations from the interpretive guidance include morning sickness, pregnancy-related migraines, needing to drink water, eat, or go to the bathroom more frequently, fatigue, needing to avoid certain chemicals, needing to avoid working in the heat, needing to avoid certain physical activities such as bending or lifting, needing to attend medical appointments, recovering from pregnancy, childbirth, or related medical conditions, or needing to limit physical activity or be on bed rest. Remember, these are just examples of PWFA limitations. There are many others. The upshot then is that the limitation has a very broad definition. However, it is not unlimited. First, the PWFA only covers limitations of the person experiencing pregnancy, childbirth, or related medical conditions. For example, the PWFA does not require accommodations to meet needs caused by the limitation of the employee's child. Second, the PWFA does not create a right to reasonable accommodation based on an individual's association with someone else who may have a PWFA limitation. For example, an employee who wants to attend their spouse's IVF treatments is not entitled to an accommodation under PWFA. Third, an employee is not entitled to accommodation because they have a physical or mental condition related to, affected by, or arising out of someone else's pregnancy, childbirth, or related medical conditions. For example, an employee who is experiencing anxiety due to their spouse's pregnancy is not covered by the PWFA. Finally, time for bonding or time for childcare also is not covered by the PWFA. Next slide. Under the PWFA, the known limitation has to be related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions. This can be met even if pregnancy, childbirth, or the related medical conditions are not the sole, original, or substantial cause of the limitation. Next slide. What does related to, affected by, or arising out of mean? Usually, this will be a straightforward determination that there is a connection. For example, a pregnant employee seeking accommodation due to back pain when standing for long periods of time has a limitation that is related to, affected by, or arising out of pregnancy. And a lactating employee seeking an accommodation of breaks to eat has a limitation, increased nutritional needs, that is related to, affected by, or arising out of lactation, which is a pregnancy-related medical condition. Next slide. The PWFA does not define pregnancy, childbirth, or related medical conditions. But because Congress chose to use that phrase, the same phrase as appears in Title VII, the PWFA regulation adopts the same meaning that the phrase has under Title VII. So consistent with Title VII, related medical conditions under PWFA, therefore, might include not only conditions that are obviously related to pregnancy or childbirth, such as gestational diabetes, miscarriage, or lactation, but also any other medical condition that is related to the pregnancy or childbirth. Next slide. Undue hardship. Like under ADA, an employer does not have to provide a reasonable accommodation under the PWFA if it causes an undue hardship, a significant difficulty or expense, based on the resources and circumstance of the particular employer in relationship to the cost or difficulty of providing a specific accommodation. The PWFA regulation also makes a few additions to its undue hardship discussion to account for the differences we've talked about between the ADA and the PWFA. Next slide. What additions? Well, since under PWFA, a reasonable accommodation may entail temporarily suspending an essential function, the EEOC's regulation includes a list of facts that may be relevant to determining if temporarily suspending an essential function poses an undue hardship on the employer, such as the length of time that the employee or applicant will be unable to perform the essential functions, whether there is work for the employee or applicant to accomplish, the nature of the essential function, including its frequency, whether the employer has provided other employees or applicants in similar positions with temporary suspensions of the functions and other duties they could not perform. If necessary, whether there are other employees, temporary employees, or third parties who can perform or be temporarily hired to perform the essential function or functions in question, and whether the essential function or functions can be postponed or remain unperformed for any length of time, and if so, for how long. Any of these facts might be relevant to whether it poses an undue hardship on the employer to accommodate the PWFA suspension of an essential function as an accommodation. Next slide. The regulation also identifies 4 simple accommodations, simple ones, that will almost always be considered reasonable when they are sought for pregnancy. These are called predictable assessments. Next slide. These are carrying and drinking water, breaks for the bathroom, sitting if the job requires standing, and standing if the job requires sitting, and breaks to eat or drink. For these specific simple modifications, in virtually all cases, the Commission expects that individualized assessments will result in a finding that these 4 things are reasonable accommodations that do not impose an undue hardship. Next slide. The regulation says that to request an accommodation, the employee or their representative must communicate to the employer that the employee has a limitation, which is a physical or mental condition that is related to, affected by, or arising out of pregnancy, childbirth, or a related medical condition, and that the employee needs an adjustment or change at work due to the limitation. Again, A reasonable accommodation request does not need to be in writing or use any specific words or phrases. An example from the interpretive guidance. An employee tells a human resources specialist that they are worried about continuing to lift heavy boxes because they are concerned it will harm their pregnancy. That is a PWFA request for reasonable accommodation. Next slide. The statute does not set out when an employer can ask for supporting documentation. The regulation explains that an employer, of course, does not have to seek supporting documentation, but if the employer wants to do so, it can only do so if it is reasonable under the circumstances. And the regulation gives 5 examples of when seeking documentation is not reasonable, such as where the condition and needed adjustment are obvious and the employee provides self-confirmation. For example, the employee needs an employer-provided safety vest that fits due to their pregnancy. Second, where the employer already has sufficient information. Third, where the request is for one of those predictable assessment accommodations. Fourth, when the accommodation is related to pumping at work, or in certain defined circumstances where the request is for time to go nurse where the child is in close proximity to the workplace. Or fifth, where other employees can get what is being requested without documentation. Those are 5 examples where the EEOC's regulation says it is not reasonable for an employer to seek medical documentation as part of the PWFA interactive process. Next slide. If it is reasonable under the circumstances to seek documentation, the employer can only seek reasonable documentation. That means the minimum that is sufficient to 1, confirm the physical or mental condition, 2, confirm that it is related to, affected by, or arising out of pregnancy, childbirth, or a related medical condition, and 3, describe the adjustment or change at work that is needed due to the limitation. Take note, the interpretive guidance says confirmation of the physical or mental condition from a healthcare provider can be a simple statement and does not need to include a medical diagnosis. Why? Because remember, under PWFA, the physical or mental condition can be even a modest or minor problem, including, for example, nausea, fatigue, a lifting restriction of any amount or any length of time, the need to avoid working in the heat, or a healthcare appointment. Next slide. The employer can require that the documentation come from a healthcare provider. Note, the interpretive guidance says the healthcare provider may be a telehealth provider, and it does not have to be the provider treating the employee for the known limitation, as long as the provider can offer the necessary information. It also says the employer cannot require the employee to see a healthcare provider of the employer's own choosing. And remember, the rules from the ADA regarding keeping medical information confidential apply to medical information obtained through the PWFA accommodation process as well, including the fact that a person is pregnant or has a medical condition related to pregnancy. Next slide. Keep in mind that workers may have protections under multiple laws, federal, state, or local. Know your jurisdiction. Some of these laws provide more protection to pregnant workers. For example, paid leave under certain state or local laws. Nothing in the PWFA limits those protections. Also, nothing in PWFA can be used to require an employer-sponsored health plan to pay for a particular item, procedure, or treatment. And PWFA adopts the Title VII language regarding the ability of religious employers to employ individuals of a particular religion. When this PWFA provision is asserted by an employer, EEOC will consider its application on a case-by-case basis. And there is newly expanded information for employers about this on eeoc.gov. Next slide. Okay, so let's look at 4 scenarios. These are based on the interpretive guidance examples 26, 27, 35, and 36. First up, Gabriella, a doctor's office billing specialist, experiences nausea and vomiting beginning in her first trimester. The nausea makes commuting extremely difficult. She verbally tells her manager she has nausea and vomiting due to her pregnancy and asks to work from home for the next 2 months to avoid commuting. Her billing work can be done from her home or in the office. First, let's talk about known limitation and the request for accommodation. Gabriella's nausea and vomiting is a physical or mental condition related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions. She needs an adjustment or change at work due to the limitation, and she has communicated this information to her employer. Next, is she a qualified employee? Yes, she can perform the essential functions of the job with the reasonable accommodation of telework. So, absent undue hardship, the employer must grant the requested accommodation or an effective alternative. What might be explored as an alternative to telework? For example, the employer could determine through the interactive process whether or not letting Gabriella adjust her hours would reduce her commute time and effectively accommodate her limitation instead of telework. Next slide. Nisha's a nursing assistant job has essential functions that typically require lifting more than 25 pounds. Tasks like helping patients dress and bathe and move to and from their beds. In her 4th month of pregnancy, she tells the employer she's been advised to no longer lift more than 25 pounds for the remainder of her pregnancy. And she requests a place in the employer's established light duty program, under which employees who are hurt on the job take different duties while coworkers take on their temporarily suspended duties. First, let's talk about the known limitation and the request for accommodation. Nisha's lifting restriction is a physical or mental condition related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions. She needs an adjustment or change at work due to the limitation, and she has communicated that information to the employer. Second, is Nisha a qualified employee under PWFA? Yes. She is asking for temporary suspension of an essential function. The suspension is temporary, and she can perform the essential functions of her job in the near future, which means generally within 40 weeks. And it appears the inability to perform the function can be reasonably accommodated through temporary suspension of the essential functions that require lifting more than 25 pounds and placing her in the light duty program. So, absent undue hardship, the employer must grant the requested accommodation or an effective alternative. Next slide. Margot works at a retail store and has an uncomplicated pregnancy. As a new employee, she has not earned a lot of leave yet and is not covered by FMLA. In her 5th month of pregnancy, she asks her supervisor for unpaid time off beyond the leave she has earned to attend her regularly scheduled prenatal appointments. First, let's talk about the known limitation and the request for an accommodation. Margot's need to attend healthcare appointments is a physical or mental condition related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions. Margot needs an adjustment or change at work due to this limitation to attend healthcare appointments. And she has communicated this to the employer. Next, is Margot a qualified employee under PWFA? Yes, she can perform the essential functions of the job with the reasonable accommodation of leave to attend healthcare appointments. So absent undue hardship, Margot's employer must grant the accommodation of unpaid time off for the appointments or an effective alternative. Next slide. Sophia, a custodian, will need 6 to 8 weeks of leave to recover from childbirth. Her mother asked the employer on her behalf. The employer has a sick leave policy, but no policy for longer periods of leave like this. And the employer has fewer than 50 employees, so Sophia is not covered by the FMLA. First, let's talk about the known limitation in the request for accommodation. Sophia's need to recover from childbirth is a physical or mental condition related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions. Sophia needs an adjustment or change at work due to this limitation. And her representative, here her parent, has communicated this information to the employer. Second, is Sophia a qualified employee under the PWFA? Yes. With the reasonable accommodation of leave, Sophia will be able thereafter to perform the essential functions of her job with or without reasonable accommodation. So the employer must grant the accommodation of unpaid leave or an effective alternative absent undue hardship. Next slide. So some key takeaways here for employers. Number one, train supervisors about the PWFA. First level supervisors in particular need to know how to recognize accommodation requests, what to do when they receive them, and how to avoid retaliating against those who request or use reasonable accommodations. Bear in mind that PWFA limitations may be minor and may be associated with an uncomplicated pregnancy. Those individuals are still entitled to accommodation absent undue hardship. And once an employee requests an accommodation, use the interactive process. Next slide. Also, realize the situation may change. An employee may need different accommodations as a pregnancy progresses, as they recover from childbirth, or as a related medical condition either improves or gets worse. Next slide. A final note on court developments impacting EEOC's PWFA enforcement. There have been a few legal challenges to the PWFA statute itself and to the EEOC's regulation. Texas v. Garland challenged the process Congress used to pass the PWFA. And in that case, a court has enjoined EEOC from enforcing the PWFA against the state of Texas and its divisions and agencies in their capacity as an employer. The court's injunction does not affect any other statutes or any other employers. EEOC is complying with this order, and the case is on appeal. There are also 3 cases challenging the PWFA regulation, specifically the potential for any accommodation related to certain abortions. The state of Tennessee versus EEOC is a lawsuit filed by 17 states. On June 14, 2024, a federal court in Arkansas dismissed the lawsuit. The states have appealed. And in the consolidated cases of Louisiana versus EEOC and USCCB versus EEOC, on June 17, 2024, a Louisiana federal district court issued a preliminary injunction prohibiting the EEOC from beginning an investigation or issuing notices of right to sue for claims brought under the PWFA that pertain to employees who sought accommodations from their employers for certain types of abortions. This applies to employees who work in Louisiana or Mississippi, and also to those who are employees of United States Conference of Catholic Bishops, Society of the Roman Catholic Church of the Diocese of Lake Charles, Society of the Roman Catholic Church of the Diocese of Lafayette, or Catholic University. Again, EEOC is of course complying while these cases continue. And with that, I'll turn it back to you, Tracy.
Well, thank you, Jean, for setting a solid foundation to help us better understand the PWFA requirements. That was a lot of information. It was just fabulous. I imagine that some people are wondering how an employer should proceed with the interactive process if the accommodation request from the employee seems like it might be covered under either the ADA or the PWFA. Which statute should they follow?
Actually, the interpretive guidance does address this question in section Roman numeral 6, paragraphs 8 to 11. The interpretive guidance has a discussion of this issue with examples. In summary, what it says is that while it will depend on the specific fact, if an employee requests accommodation for pregnancy, childbirth, or related medical conditions, and an employer thinks it could be covered under either PWFA or ADA, then in most cases, the employer should begin with the PWFA, because the PWFA definition of limitation more broadly includes even situations where the problem the employee is experiencing is not an ADA substantially limiting impairment.
Okay, thank you. That's very helpful. So now we're going to shift gears a little bit and talk about the interactive process on the next slide. Now, the term interactive process is used under the ADA and the PWFA. According to the PWFA, employers and employees with known limitations due to pregnancy, childbirth, or related medical conditions, they can collaborate through this process to determine suitable accommodations. Now, this process does not need to be formal, nor does it need to be time-consuming. Remember, there are no magic words that must be used to ask for an accommodation, and there are no required interactive process steps that must be followed. And in many instances, the appropriate reasonable accommodation may be obvious to either or both the employer and the employee with the known limitation, so that the interactive process can be a brief discussion. In fact, EEOC says the request and granting of the accommodation can occur in a single informal conversation or a short email exchange. So kind of keep all of that in mind. Now, during the collaborative process, it's essential to be aware of certain certain considerations and some practical tips, if you will, as you move along with a process. First, employers know your responsibilities under federal and state pregnancy-related laws, so your HR managers and supervisors, etc., so that they know when and how to recognize and respond to accommodation requests. Jean mentioned earlier there can be other laws that come into play, of course, but importantly, we want these individuals who are likely to receive an accommodation request to be prepared to respond and move forward with that. Of course, there are technical assistance resources provided by the EEOC and also the Department of Labor to enable you to train staff and develop effective accommodation policies and procedures. And Jean mentioned some of those, and they are also included at the end with these resources. Also, employers are encouraged to create a safe and supportive environment where employees are comfortable communicating their accommodation needs and engaging in an open dialogue with the employer. Creating this environment, it does involve a combination of policies, practices, and cultural shifts. So for example, ensure that transparent communication about the company's policies regarding accommodations and support is available for employees who are pregnant or recovering from childbirth or nursing. Encourage people leaders to model supportive behavior and establish an open door culture where employees feel they can approach their manager or HR without fear of retaliation or negative consequences. And also offer flexible work arrangements such as remote work, flexible hours, and part-time options that can help accommodate employees' related needs. These efforts can facilitate productive interactive process conversations. Now, if the employee is seeking modifications like easy access to water, additional restroom breaks, sitting or standing as needed, or breaks to eat and drink, you do want to implement these accommodations when it's reasonable to do so, as Jean mentioned. But of course, in some situations, to determine an appropriate accommodation, the employer and the employee, they may need to engage further in the process and may need to analyze the particular job involved and determine its purpose and the essential job functions as well. But most often, accommodations can be decided and implemented with brief discussion for the most part. If the accommodation is a PWFA predictable assessment, again, implement the accommodation without delay. Note that this same unhindered approach can be used to provide other types of accommodations identified through the accommodation process. So any PWFA accommodation can be implemented without a time-consuming process and without obtaining documentation. Documentation is never required to provide a PWFA accommodation. Now, as Jean discussed, when documentation is deemed necessary, assess whether it is reasonable under the circumstances to seek supporting documentation and limit it. Remember that confirm, confirm, describe rule that Jean mentioned earlier. So for example, if an obviously pregnant employee who's seeking a bigger uniform because of their pregnancy, this is something where you would not need documentation in order to move forward in providing that accommodation. Every accommodation is unique and it should be addressed individually, of course, taking into account the specific circumstances when that need arises to explore solutions, and sometimes it will. Jan can help with finding effective workplace accommodations. But the EEOC gives us an easy place to start with the examples of possible reasonable accommodations in the PWFA final regulations. So this is a good place for you to start in terms of sort of knowing what might be considered reasonable. Of course, Jean mentioned these earlier, but just to recap, some of those accommodations include things like allowing breaks, providing a stool to sit on or a way to do work while standing, maybe providing a uniform or safety equipment that fits. It could be changing a work schedule to allow shorter hours, part-time work, or a later start time. It could be telework where that is reasonable and possible, and maybe it's those temporary suspensions of reassignment or a temporary suspension of an essential function if that's something that is possible to do, light duty or help with lifting, or it could, again, be leave for healthcare appointments or to recover from childbirth or other medical conditions related to pregnancy or childbirth. So consider these accommodations and beyond when you're exploring your options. And again, keep in mind that every situation is going to be unique, and we want to ensure that we're considering the individual circumstances involved in every accommodation situation. A final tip, of course, is when you're exploring accommodations, consider the preference of the employee to be accommodated and select and implement the accommodation that's most appropriate for both the employee and the employer. Now, with all of this in mind, again, just kind of remember, these are some ideas, sort of tips and considerations to think about as you're engaging in a process. But ultimately, it's really about just working together collaboratively to come to a solution that is going to enable that individual to continue to work during the pregnancy, and accommodations can make that happen. Now, a final key takeaway regarding the interactive process is the significance of effective communication. Now, while navigating the interactive process, we can offer some tips to consider. First, seek to collaborate, not contest. So rather than approach the accommodation process as adversarial, assume that all parties want the same thing, an effective solution. When parties collaborate to solve problems and address concerns, it's more likely that they'll find solutions that benefit everyone. Be open and honest. Transparency really is crucial for effective communication. Transparency in communication involves being open and honest about decisions and policies and other information relevant to that accommodation process. Also, be crystal clear. Even unintentional misunderstandings can lead to conflict, so don't assume that others know what you mean. Communicate clearly so that everyone is on the same page, and be willing to answer questions and provide clarification when it's needed. This way, differences in perspective can be addressed and issues can be resolved quickly. Also, be forthcoming. It's important to loop others in to new information that might be available or developments as they occur in that accommodation process. For example, if there is a delay in processing an accommodation request, reach out to the individual so they know the status of their request. Also, listen actively. Effective communication requires that all parties listen actively to each other, and you want to seek common ground and show mutual respect for each other. And stay open-minded. Sometimes our perspectives limit our understanding of a situation, so don't assume that your way is the only way. We want to ask questions in good faith rather than rhetorically, and be willing to adjust your viewpoint based on new information to allow for a more constructive, interactive dialogue. Of course, we know there won't be a one-size-fits-all solution for most accommodation situations, but armed with these communication tips, you can build a collaborative dialogue that will encourage perspectives and help resolve conflicts and lead to effective accommodation solutions. And that really should be the goal. Now, we will wrap up here with just offering some resources that were mentioned earlier. These will help employers navigate the PWFA accommodation requests. EEOC has really done a great job of providing resources and practical information that is very helpful in terms of sort of trying to figure out all of this new information around the PWFA. Of course, Jean mentioned that what you should know about the PWFA and also the summary of key provisions of EEOC's final rule to implement the law. I'll also point out there is an Appendix A to Part 1636, Interpretive Guidance on the PWFA, which is very helpful, and it includes a number of examples that can be useful when you're navigating the accommodation process. Also, Jan offers some resources on pregnancy-related situations. So we have an A to Z on pregnancy and some others to help with the accommodation process as well. And then, of course, the Department of Labor offers some resources on the FMLA, which could come into play, and also that Providing Urgent Maternal Protections for Nursing Mothers Act, or the PUMP Act. So you might need some information on that. Jean also referenced that there are a lot of state and local laws that could come into play, and so you want to ensure that you're familiar with those protections too. We do have a link here on the slide. The Department of Labor offers some links to state and local government resources that you can learn more about. So with that, that's the time that we have today. We hope that this training has really elevated your understanding of the PWFA and the accommodation process. Jean Goldberg, we sincerely thank you for your time and your expertise on this topic and your partnership. Jean has been so helpful and has worked with us for years now in providing content for our Jan webcasts, and we so appreciate you and really have enjoyed this partnership. So thank you so much. This training was outstanding, so we appreciate it. For more information on accommodation topics, you can, of course, ask Jan. So we certainly help employers and people with all types of health conditions and disabilities find effective workplace accommodations. If your questions were not answered through the content that was delivered today, you're welcome to contact the Jan service for more information. We can also direct you to the EEOC if it seems appropriate to do that. So give us a call at 800-526-7234. You can email us at jan@askjan.org or go to the Jan website at askjan.org. There you can also use the live chat. And if you're not already following us on social media, we certainly do hope that you will. Find the Job Accommodation Network on Facebook, LinkedIn, and YouTube, and at Jan on X. Thank you so much for joining us today. Please do enjoy the rest of your afternoon, everyone. This concludes our training.